So just to introduce myself, my name is Mark Gracie, and I work with businesses and organisations on their GDPR and data privacy compliance. My background is one in I became a data protection officer in 1998 when the old Act came into force. I was working in an internet business at the time, and so we had quite a lot of data to pull into control under the regulations, and I've been working in mainly internet but data related compliance in a business for about 20 or so years. I think most of the people that are joining this call or have registered to receive a recording are probably data protection officers in multi-academy trusts or in schools, and that was obviously the whole point of the webinar, hence the title. I can I guess in some ways sympathise and sort of reflect upon my own experiences of being a data protection officer for a multi-academy trust as well, because one of the services I offer is a outsourced data protection officer service, and I work with different businesses as a data protection officer on their behalf, including a multi-academy trust. So the talk is going to be about some key challenges with some thoughts about how you might address those challenges. Hopefully there'll be some things there that will be of interest. I'm sure that some of you will probably experience the same kind of challenges or may already have your own approaches to dealing with them, and in terms of some of the things that need to be done, challenges in themselves, but we'll work through that. And whilst I was preparing for this presentation, it wasn't too difficult to come up with quite a significant list of resources, and this fan diagram sort of kind of highlights some of the key things that I identified as those challenges, and we're going to sort of pull out a few of those as we go through. So as I say, there's 5 key challenges, and we'll look at each of those in turn with some thoughts about what the solutions might be. But we of course mustn't forget the regulator, the Information Commissioner's Office, who, well, to be honest, hasn't done much in the, well, I'm sure they've done a lot, but they haven't done much GDPR related enforcement over the last year and a bit, which means that we're slightly unsure about interpretation of certain elements of GDPR, but there's always a good quote coming from the Information Commissioner herself. And the one I chose there was one that she said earlier this year about the accountability principle, which of course was one of the key principles introduced with GDPR. This position of it's not good enough that you are compliant, you have to prove it as well. And it's quite clear from what ICO have been saying and Elizabeth Denham has been saying, is that a lot of people are doing their best to meet this accountability principle, but there's still a lot of work to be done along the way. And of course, I think accountability, documentation, evidencing every single step, let alone dealing with day-to-day challenges, is a challenge for any organisation. So whether we'll see more from the accountability and enforcement in general, I guess time will tell. And then I've just sort of listed at the bottom there, I couldn't decide whether point or a separate slide or whatever, so I just added it at the bottom in case you didn't realise that the ICO carry out consensual audits, and essentially they tend to occur if somebody has brought an issue to the attention of the ICO. That might be an organisation has told the ICO they've suffered a breach, or that one of the organisation's data subjects has complained or raised an issue. Then it's possible that the ICO might get in touch and say that they'd like to carry out a consensual audit. And the audit tends to take the structure of a sort of a 3-day interview with various key members of staff, and looking at typically 3 key areas. I think there's about 8 different key areas that they can pick from. And then what they do is then produce a report setting out some of the challenges that they identified and recommendations for improvement. It tends to not be a punitive action in terms of outcome, in the sense that if they find things that aren't right, then there won't necessarily be a fine or any further investigation, but there's usually a follow-up to make sure that the recommendations have been implemented. Now, the reason I raise this is if you look at the ICO's list of recent consensual audits, you'll see that there's been 8 targeted at multi-academy trusts since November last year, so not quite a year. And indeed, actually, if you look at the majority of the consensual audits and the various other reviews that they carry out, most of them are either in education or in health. So the challenge is on. There's lots going on. Maybe you're on the call and you've had one of these consensual audits, and will probably know a bit more about the context of it all. But it's just something to watch out for. That I think as a DPO within a multi-academy trust myself, it's one of the worries that there are so many things going on, and the things we're going to be looking at, that you just hope that stuff going on that you don't yet know about, and you don't get approached by the ICO for a consensual audit, I guess. So let's move on to the challenges. I've sort of picked sort of a couple of very specific sort of practical things, and a couple of more sort of high level challenges. The first one is a challenge that I think will probably impact everybody in education, and that's the fact of term times and school days, and the expectation of the people involved working within the trust, the expectation of the parents, and some of the challenges associated with some of the time limits that are set out in GDPR terms. So from my perspective, the key thing here to talk about is 2 key GDPR time limits. So we've got individuals' rights, which are the rights of the data subjects. So that's going to be parents, pupils, employees, for example. And the GDPR says you essentially have a month in which to deal with a range of those rights. Probably the most common and probably the trickiest ones that you will be dealing with are subject access requests, of course. And the ICO recently published an update to say that when we say a month, we actually mean a calendar month, which means that it's the same day in the following month you have to respond to. So that does mean if you get something on the 31st of January, you'll have to respond to it by the 28th of February, because there is no 31st of February, unless it's a leap year, of course, in which case it would be the 29th. And the sort of day one of that calendar month starts on the day that the notice arrives. So so there are clear challenges about subject access requests, and we'll talk about one of the challenges from a parents and carers perspective a bit later on, in fact the next challenge. But aside from that, you have this challenge with regards to the fact that you only get a month to respond to a request. So what do you do when the the academies are shut down for 6 weeks in the school holidays, and the individual data subject serves the request on the last day of term? How are you going to pull together all of the information from there? And then, of course, if you suffer a breach, we get 72 hours to determine whether we think it's a reportable breach, and we have to tell the ICO about it. Again, that's a challenge when you're dealing with weekends and when you're dealing with half terms and the main school holidays, and how with those and the obligations of what the GDPR requires versus the practicalities of how the academy are being run and the trusts being run. So I'm sure this is a real challenge. I've certainly found it a challenge for some of the work that I've done, and it's the same in business as well. It's not just something that's unique to education. People do go on holiday, and how do you deal with that? And the quote at the top is actually from a blog post from the ICO. Data protection doesn't take a day off. It was actually relating to a company, Farrow & Ball, who failed to register themselves as a data controller under the new regime, and they were taken to court mainly for ignoring the ICO. And I think one of their reasons that they gave for not having paid the data protection fee on time was that the person who's responsible for it took a day off or was on holiday, and the ICO are making a clear dig here that actually doesn't matter whether you've got people on holiday or not, and they're the ones that are responsible. You need to have policies and processes in place internally to deal with that. So I think it's probably quite a cheeky headline, I guess, to use, but they did say data protection doesn't take a day off, and it's not just about the registration fee. They're making a clear point here that data protection applies 24/7, 365, and we all have to try and work around that. So in terms of what that working around actually means, well, for each of the challenges, I've sort of come up with 3 highlighted areas of things to think about. In my mind, the clearest answer is setting expectations in your privacy statement. So you should be having a privacy statement for pupils that's understandable by the pupil, and that may be also the one that you give to perhaps the parents or guardians or carers. But in your privacy statement about individuals' rights, because those are some of the things that have to be included in the privacy statement, and you might call them privacy policy or privacy notice, same thing. Talk about the fact that at times of school holidays, then there may be a delay and it may not be possible to meet you'll do your best to achieve the appropriate deadline, and will be and make sure that you communicate to them that that deadline may be extended for those reasons. Obviously have a clear internal process around subject access requests, which also addresses this particular issue about what to do with out of hours approach, and that can be anything from making your DPO at Academy email address gets redirected to somebody when the DPO is on holiday or an event, and likewise for phone numbers. And of course, I think most schools will probably have a reception or a general inquiries number that's picked up on a regular basis. So it's about also educating those people about what to do if somebody is contacting them about a subject access request, or opening the post and finding a letter requesting it. The biggest challenge, of course, is email addresses and how you deal with that. And whilst the majority of sort of public-facing email addresses probably have an out of hours, an out of office response, then that's the which you might want to communicate that if it's a data protection thing, then you might want to contact this email address or call in or something like that. So have set clear expectations in your privacy policies. Make sure you have an internal policy that sets out how you deal with out of hours, and also try and implement as many sort of out of hours, out of office type answers and feedback when people try to contact you, particularly through the main contact point that you've published in your privacy notice or on your website protection inquiries. Now, the downside from a breach perspective is that you get 72 hours from the time you become aware to tell the ICO. And if you think a breach has occurred, but you're not quite sure what the details are, or being able to sort of determine it is something that's reportable, the ICO kind of indicate that you need to tell them anyway. So you would have to consider that a couple of things from a breach perspective. One is if somebody in the organization identifies something that looks like a breach, that it's brought to the attention of the DPO as soon as possible, because the 72 hours ticks when the academy or the trust gets to hear about it from sort of the outside world, I guess is a way of looking at it, rather than when the DPO gets to see it. So that needs to be picked up and dealt with. So all the same previous comments about making sure that there are out of office contacts available for people who want to report breaches internally or externally. But you will have to consider that if that's not doable in terms of the 72 hours, because you need to talk to colleagues who are still away on holiday or are not likely to be back in enough time, then you may have to consider telling the ICO that you've suffered a breach, but you're not sure about the details yet. You're still looking into it, and it's been hindered by school holidays. Obviously, you want to try and avoid that as much as you possibly can, which is why, going back to that previous point about having an internal process for out of hours is an advisable approach. So that's challenge one, dealing with term times and sort of school days. And the other aspect is not just about school holidays. You also have to consider the fact that staff might finish early-ish on a Friday, and you get a breach at 4 o'clock on an afternoon on a Friday. How are you going to deal with that if you can't get hold of staff because they've gone home for the weekend or whatever, particularly if it's a bank holiday weekend as well. So moving on to the second challenge, parents and carers, and I kind of alluded to some of the issues in the previous one with subject access requests, and that's really what an element of this particular challenge is about. Of course, what probably the key things, and let's just go straight to it. I mean, even the key things here are that parents will have certain expectations about what data or what information they can expect to receive about the progress of their son or daughter. And there are some questions about whose data is it anyway, in terms of every pupil will be a data subject, even though they may be afforded all the rights of any data subject. So it doesn't matter that they're a child, it's still their personal data. And then there's some questions around how you deal with a parent asking for information about a child who is a data subject. You give the information over to the parent because it's the pupil's data, not the parent's data. And there's also the Department for Education's and the government's view that every parent's entitled to an educational record. So you have to be clear what is covered in an educational record, and everything else you have to treat as a separate subject access request that would be a third party asking for the data of another party. Therefore, that means that you have to then look at the age of the child and the competence of the child. And I'm sure you already know this sort of threshold of if the child's over 12 and doesn't have any particular issues, which would mean that they couldn't comprehend the consequences of having a discussion about data protection and their rights, then the data is clearly the child's, and you have to get the child's permission before you hand it over to the parent or guardian. And if the child is under 12, then under 13, then the parent is deemed to have parental responsibility, which then takes us on to the next issue within this section, which is about who has that parental responsibility. And I think that there's no immediate answer to this. There is a paper from the Department for Education about when a parent actually is a parent and the complexities of modern family life, and parents with parental responsibility, but where the pupil no longer lives with that parent and has moved to a different parent or carer. So it's important that you are clear before you disclose information, particularly with subject access requests and some of the other individuals' rights we'll be giving out data, that you're clear about who you're actually dealing with and whether you need the child's permission. So when it comes to looking at those, this sort of key challenge, then I see these as the three things to focus on. Basically, again, your privacy policy should be setting expectations, so it shouldn't hopefully become too much of a surprise to a parent or a carer or a guardian to understand that there may be some challenges depending on what they want to see relating to the information about their parents. So, in your parental privacy statement, you should be setting out about the right to be informed. Sorry, not the right to be informed, the right of access and what that actually means in practice. And also that you will have to carry out some verification checks, which might involve the son or the daughter, or potentially not be able to provide the information unless they're able to demonstrate that they're actually a parent with parental responsibility, although generally from a school perspective you probably have a good concept as to who the parental responsibility lies with. Again, as with always, having an internal policy about how you deal with these requests, particularly where parents are involved, and your interpretation of the guidance about when's a parent for the purposes of parental responsibility, then you'll have that documented, and of course also make sure that it's clear to your employees and your staff to make sure that they completely understand the consequences of handing out the data to the wrong person, and the complexities of when's a parent and when when it's the pupil's data and not the data that the parent's entitled to. And of course, some of the there's also some sort of not very clear guidance about educational records in a multi-academy trust scenario where state-governed schools, they have to be able to provide them. A multi-academy trust, it tends to be left to the academy trust to decide what its policy is. So you might want to make sure you've got that clearly documented as well. And I think the other thing is, this isn't going to be the I'm sure we're going to see stuff in the future from the Information Commissioner or the European Data Protection Board or even the Department for Education about some of the changes and updates to understanding the complexities around providing pupil data as part of a subject access to a parent or a guardian, as well as the complexities of what is pupil data and what's not. And I know the ICO is working on a code of practice for online services targeted at children. So it's sort of taking the data protection design and default approach and applying that to children's services. And there are also references in GDPR about the sensitivities of processing children's data. There's a bit of information on the ICO's website, but not incredibly large amounts. So no doubt we'll get some more guidance. So I'd say the action there is monitor the situation and keep an eye on any guidance or direction that might come from any of the regulators or even the government. So that's challenge 2, how dealing with really parental expectation as to access to data via a subject access request. Moving on to challenge 3. This is more of a sort of so there's 3 more to go, and this is the first of a sort of top higher level challenge rather than something more specific. Now, and I speak to lots of data protection officers, not just in academies and education, but in other sectors as well. And I think probably resource and maintaining compliance, which is one of the other ones we'll get to in a moment. But resource is one of the key challenges that I think every organisation has in terms of how they implement GDPR compliance. So we have to look at what the GDPR expects us to do, which is basically do everything we possibly can technically and organisationally to ensure that we are compliant and are able to demonstrate that in accordance with the regulation. But the resource challenge is basically paying the time and effort it can take for dealing with various different GDPR issues, particularly if you are suffering from breaches or you have a large number of subject access requests to deal with, then you'll always have resource challenges, and it's not cheap dealing with these issues. They can drag on for a lot of time, and you will have people in the business who have got their day job to get on with. And as it says on the left, everyone's always busy, so you're going to be interrupting them and asking them to find some data for you, and you need to do that within the confines of the time limits. And earlier, those might be tighter than originally intended because of school holidays and weekends and things like that as well. But you're also dealing with potentially multiple sites spread out across a region or even the country. So you've got the trust itself. Your trust may be in charge of a number of or oversee and manage a number of academies, which may be in a local area, but certainly some that I've seen are spread out across the country. So you're dealing with essentially one organisation in charge of lots of other mini organisations. So they tend to be running themselves, and they have their own internal processes and policies, and where possible, hopefully that's controlled and dictated by the overarching trust. But having different sites and can make it quite disjointed in an approach. And then also you've got various ranges of different people that you're interacting with, from suppliers to teachers to temporary staff to staff working in the kitchen at lunchtime and so on. So there's quite a lot of different people to reach, and rolling out a training program, for example, for a multi-academy trust isn't easy when it's multiple sites, and you can't just, like a lot of businesses can do, is to say, right, we're having a day's training day and we'll shut everything down and you come to this location and deal with it. You just can't do that in education. So there's quite a few challenges in that resource space. In terms of addressing those, the thing that I've certainly found has worked, and I know other organisations have implemented this as well when they have different parts of their business spread out across the country or even a region, is to make use of what I call data champions. So that's somebody who takes responsibility within each of the academies or schools, and they can act as your eyes and your ears in those academies and schools. The concept there really is that as a data protection officer, you can't be in, I don't know, 5, 6, 10, 50, 100 different places all at once. You need to be able to spread yourself as wide as possible, and these data champions can help you with that. And you should keep, if you have that network in place, then I think I certainly find that really helpful in the multi-academy trust that I work with. And we have regular meetings to discuss changes in approach or issues, things that have cropped up and so on. So keeping that network of data champions going, I think, is a great way of doing it. The downside, again, is still a resource issue, because you're likely to be, for want of a better word, lumbering somebody within the academy to take on this position, and they'll probably be busy doing other things. They might be the business manager, HR manager, or whatever. But I think from a process point of view, having that kind of data champion network is a great way to try and manage that spread of location and also diversity of workforce. And I've seen, certainly in some of the consensual audit reports summaries that I've seen on the ICO's website, that they've commended some trusts for having that kind of approach in place as well. So if you're not doing it already, then it's might be a well worth thing for you to take a look at implementing. You also want to the ears or the attention of somebody in the trust board or one of the trustees, depending on how your trust is being run. So somebody that is overseeing will need responsibility for data protection. So you need to have a director that, or a board representative who is taking responsibility for data protection, and you should be raising issues on a regular basis, maybe a monthly report to the board, for them to have that as a standing item on their agenda to just talk about data protection issues. And unless you're not suffering from subject access requests or breaches or any other of the data protection challenges, which I suspect you probably are, there will be probably something for you to report nearly every month. So it's worth making sure that you've got that structure in place, as well as the data champions in each of the academies. Make sure you've got somebody at board level who is taking responsibility for this, and you're able to report to them or to the board as a whole about your role as a DPO. And of course, as a mandated DPO, you've got to have that route into the board anyway. It's one of the requirements of a mandated data protection officer. And then finally, of course, the best you can do is roll out training, and that training needs to be refreshed. And there is this expectation in Article 24 that the accountability principle and the things you're doing to comply with GDPR need to be done on an ongoing basis, and you also need to make sure that they're tried and tested, and that's no different for training as well. So you need to work out how you're going to deliver that regular training. And there's lots of evidence in the various audit reports that the ICO have published, some of those summaries for the consensual audits I was talking about in the beginning, that highlights that there is an expectation that you do training, that you monitor who is actually taking part in that. So it's going to be difficult getting everybody in a room at a particular time teachers are under a lot of pressure as it is to learn and have get as much into an inset day as they possibly can. And now you want to talk about GDPR as well, which lots of people will have heard about anyway, and probably last year were sick and tired of hearing about. But you've got to somehow get in place a structure for maintaining education and awareness around GDPR, particularly when things change. And you can do that from having an annual training session in some way. But as I nearly got to say, but I got distracted. In some of these consensual audit summaries, the ICO have made it clear that you should be able to demonstrate who has and hasn't had the training, and that if you're using third-party packages like an online system, that there are mechanisms within that system to make sure people are actually paying attention and not just jumping to the end and guessing the answers to a quiz at the end. So there are some obligations on them that the training method you're using is working as much as delivering the training in the first place. Maintaining communication. I send out as often as I need to, but try and keeping it as regular as possible, briefings to all staff to help them understand certain complexities around some of the things. So, for example, the last thing you need are members of staff suddenly using third-party data processors because they've decided to use an online service that helps with students doing their homework, for example, and they've passed over pupil data and teacher data and so on to this system without making sure the due diligence is carried out. So why not put together a pack of information, put it in the staff room, send it out as a briefing that explains why it's important that you as a data protection officer get to understand what systems are being used or want to be used before they get used, so that you can carry out data protection impact assessments, or you can carry out due diligence on those third parties if necessary. So regular training and communication with employees is as important as anything, particularly when covering so many different employees over so many different locations. It's going to be tough to roll that out, but that's something that's quite key. And as I say, the consensual audit summaries that I've seen imply that that's there's a no-brainer. You have no choice. You need to do the training. The tricky bit is how you do it and demonstrate that you've done it appropriately and sufficiently enough. Right. So that's resources as a challenge. There's also maintaining compliance. It's easy, I think, for people to have forgotten, and being DPOs, we of course wouldn't have forgotten, but there's a lot of people out there who have this opinion that maybe GDPR is all about May 2018 and it's not so important anymore. So you've got that challenge of maintaining that education and awareness, which are some of those communication tools we're talking about just before the training, and the maybe a monthly briefing or something is a great way of doing that and maintaining contact with the board as well. But there are general challenges with keeping up your compliance. There's the data discipline point around making sure the staff are still doing what you expect them to do based on the company policy and what the GDPR allows you to do, and that they're not going off and doing their own thing, sharing data here and there, and that there are controls in place. You've got to keep up to date with any new guidance or anything that changes. The thing with the GDPR is it's a European-wide regulation, so if something happens to an organisation in Europe, and I'd say a German regulator decides to dish out a fine for a particular reason, then it's important to understand whether that fine could be an issue in the UK and how that might be implemented, because we've now got this sort of one-stop shop. In fact, that's the term they use, one-stop shop of all these regulators across Europe who are working towards a common cause of general GDPR compliance across the whole of Europe. So we have to pay attention to what the Europeans are doing as much as what the UK's ICO are doing. And whilst there is a bit of sort of a toolkit from the Department for Education, you need to pay attention to any changes to that or any other recommendations in that area, particularly in the processing of children's data. And then, of course, don't forget, you've got your day-to-day business as usual stuff, dealing with third-party processes, data protection impact assessments, the individual's rights, particularly subject access, with breaches, dealing with data sharing agreements, and so on. So that maintenance of compliance is an ongoing, which I'm sure I don't need to tell you about, because I suspect you're living it on a day-to-day basis anyway. The quote there at the top is from Article 24 of GDPR, which basically says you have to comply with GDPR. Also says at the end you have to make sure you review and update where necessary. So that's the bit that means you've got to keep up to date and understand the changes and update your processes and your procedures accordingly, and may change things because from carrying out data protection impact assessments or dealing with an issue, you've identified something that's not quite working as well as it should be. So three things to think about. As I said before on the previous challenge, it's a lot about, I think, whether you talk to somebody about data security, cyber security, data protection, whatever, the weakest link, for want of a better word, is usually the human in it. So it doesn't matter how strong your policies and processes are, it doesn't matter how strong your technological systems are, there is a potential for a human to make an error. So yes, you may have your computers locked down so that you can't automatically install software that might be virus infected, but it doesn't stop somebody accidentally CCing everybody in an email address when they shouldn't have done, or sending the wrong student reports to the wrong parents, and so on. So that human factor is probably one of the key things that has to be addressed. So keeping up with the training and the refresher training, and the communicating with staff, perhaps via your champions, keeping your champions up to date with what's going on, with regular contact with them as well, is got to be key. You also want to build up as many internal policies which you can tell your staff and the processes and the guidance. So if you've got something like an intranet or an internal server which you keep policy documents on, I mean, multi-academy trusts have a suite of policies anyway, because you've got to think about safeguarding and all the other things and the legal aspects of running a trust. So you've probably got the infrastructure in place already, but you want to have a look at what other bits of information you can make available so that staff can get access to it quickly and easily, or even if it's a glancing look to see whether they need to talk to you about it or whether there's an immediate answer. You can't just rest on your laurels that everything has stayed the same and you don't need to do anything further. And I think there's a lot of businesses who seem to think that they did everything ready for GDPR last year for the deadline, and they probably don't need to do anything more. But there is an expectation, as that Article 24 implies, that you should be regularly reviewing your compliance and making sure that you've still got all the right things in place. So does your data register still list all the data that you're processing? Are your processes still your processes, or have they changed their terms and conditions? Have you checked that your processes are indeed still compliant? And again, from these consensual audit reports that I've seen on the ICO's website, there is a hint there that we should be picking on some of our processes. And so, if you're using, I'm sure you're using lots of third-party cloud-based solutions and storage and things like that, you should be really making use of that contractual clause that's in the data processing agreements about carrying out an audit on them, asking them some questions and making sure that you're happy that should you be challenged, you can say, well, we spoke to them and they gave us all this as an answer and we believe that was appropriate. Of course, the problem with that is there is no clear guidance about what kind of detail you need to do in those kind of reviews and checks. So, saying to somebody, are you GDPR compliant? And they say, yes, they are. You can say, well, then I've done my spot check on that particular processor. But I suspect you probably ought to be doing a lot more than that. And on the subject of spot checks, you should be looking at what how you can check some of your processes and policies internally are working. This takes us back to resources again, because there isn't enough time in the day to do the day job, I suspect, let alone think about whether you can serve a dummy subject access request into a trust, into Academy, and see whether it follows through the process and you get to hear about it as the data protection officer. But there is a hint in one of the consensual audit summaries I saw that that's exactly what you ought to be doing, is you ought to be testing the waters to make sure that all that training you've delivered and the policies and processes you put in place are actually being upheld. Yeah, so training and communication, resources in terms of policies and guidance and process documents, and you're going to have to do some reviewing to verify that you're actually still compliant and in fact the policies and processes are being followed. So yeah, so solutions, but not solutions that don't require resource, unfortunately. So these first four have been sort of about a couple of specifics, a couple of sort of top level things like resource and managing that compliance. But one of the key things that I've mentioned a few times is basically keeping up to date. And of course, the other challenge with that, and I know from talking to various organisations in education or otherwise, that one of the biggest challenges is getting sensible advice when you need it. And I think the challenges that faces everyone, and the education sector is no different, is that the ICO's guidance is very limited. The European Data Protection Board, or the Article 29 Working Party guidance that existed before the EDPB came into force, is very limited as well. It doesn't, they provide lots of examples, but they seem to be able to pick out examples that don't actually exist in your particular scenario. The ICO helpline can be quite vague and unhelpful, and I'm sure if you've tried to talk to them, you get told to go and read the guidance, which you've already read, which is the reason why you contact them in the first place. And they essentially conclude that it's up to the law. And in fact, this sort of element is the thing that I find quite exciting about data protection, is that the law is quite black and white in the sense of that you must do these things, you mustn't do these things, and you must allow for these things to happen. But it doesn't deal with the complexity, and it's all down to the interpretation. And of course, the regulator is slightly in a difficult position, because if they start handing out practical advice, it will become a sort of precedent for particular things. So it won't be a properly considered situation like an enforcement notice would be. You may use lawyers, of course, and the downside of that is they can be expensive. There's limited available information from the Department for Education. They do have their toolkit, which sort of covers the basics and gives quite some helpful pointers, but it is limited limited in itself. There is very little guidance and information from the regulators about how they expect elements to be interpreted and how the law is to be interpreted. And so we see this all of the time. And unless you're reading enforcement notices or you're looking at these consensual audit summaries as examples, you won't get to see the understanding of where sort of like the mind of the ICO and where they're thinking with regards to these things. So certainly these consensual audit summaries give away quite a lot of interesting pointers as to expectations, and I sort of touched on a few of those as I went through. So, but they don't tend to shout about these. Yes, they write a blog about some of the enforcement notice. There was an enforcement thing to do today with some marketing stuff, not today, I think the end of last week, with some marketing infringements. Nothing out of the ordinary in terms of enforcement, I don't think, but again, there was no report about that, and you have to go to the enforcement section to see it. And they don't tend to sing and dance about the consensual audit summaries, and they don't tend to shout very loud about when they introduce more complex guidance. It's about having to follow them on LinkedIn or on Twitter to see that they say, we've just written some new thing. Well, of course, that all depends on the algorithms as to whether you see it in the first place. So there's quite a lot of issues here about understanding what the regulator is thinking and how that would apply practically to your situation, which is all part of keeping up to date as well. Now, rather cheekily, I have a solution for this, and I suppose you could argue there's no such thing as a free webinar, so I'm afraid it's a quick sales pitch. So as I said, I run a service called the Digital Compliance Hub. It is primarily a support helpline helping businesses with GDPR and data compliance via email and phone, and I've just introduced online chat support as well, and it's backed up with a library of resources. So there's policy templates, there's alerts, there's updates, there's opportunities to join webinars, which are for non-members is usually associated, and there's either free for hub subscribers or discounts. And I've just introduced a range of what I call hub assists, which are things that you can bring to me that you need specific help on. So specific advice about subject access, input into a data protection impact, a report or a third party's view on whether you need to report a breach to the ICO or the data subjects, that kind of thing. So there's a bunch of tools within this. The subscription is 125 plus VAT a month. So I believe it's a very cost-effective way of getting the help that you need, and more importantly, the help that you specifically need for your particular problem at that particular time. None of this ICO sort of grey area. Well, it will depend on how you want to interpret it, and you'll have to write it down to decide whether it's right or not. We will get to know your organisation. We've got experience working with multi-academy trusts as well, so we will be able to work with you and help you. And it's a subscription-based system, but if you sign up today, at the moment we're running a free 14-day trial, so you can try it for a couple of weeks. And when I say try it, I mean properly use it. So if you've got a breach situation that you need to you could do with some input on, make use of that free trial, and we'll have a talk and chat about that. Right, so I've probably spoken a bit longer than I originally intended. We've still got 10 minutes, so there is time for questions if you have any. I'm just going to have a quick look at the questions panel to see if there's any questions. So if you've got any questions, use that control panel. Sorry, use the GoToWebinar control panel, the questions section, and type in your question. I'll pick it up. I've got one there. Let me just read that a second. Okay, so yes, there's a good question here about the independent inquiry into child sexual abuse, where there was some guidance published about retention of data for the purposes of dealing with historical abuse cases, and the conflict there with general practical guidance points on things and so on. So my take on this is that the inquiry is basically the government saying, and I know it's independent, but it's basically saying that you have a reason to retain this data. And of course, the GDPR says as long as there is a lawful basis for you to process the data, of which retention is one of the ways you might be processing data, then it's lawful for you to do so. So I think that this current situation where we're all being asked to retain the data for the purposes of falls within the need to keep the data for that purpose, and it would be lawful for you to do that. I'm not sure if I particularly answered your question, but if you want to sort of look into that a bit further, then drop me an email and we can discuss it further. Okay, any other questions? Nothing else has come through since I was dealing with that one, which seems to be the only one that's come through. Does the Department for Education have a template for privacy impact assessments? And I think the answer to that is it doesn't, but the Information Commissioner does. The old style of Information Commissioner way of doing it was you would have a set of screening questions, and if you answer yes to any of those screening questions, then you have to do a much more detailed assessment. But if you go to the ICO's website, go to the GDPR bit, look at the I think it's in the accountability or governance section, data protection impact assessments, there is a little template you can download of the main questions that you should be asking yourself, which you can use as a way of carrying out data protection impact assessments. But I don't think the Department for Education has one. Okay, well, there's nothing else going through. I hope you found the session useful. I'd really like to talk to you if you're interested in learning a bit more about the hub and how we can help. But if you have a question and it comes to your mind and you wish you'd asked but you forgot, then feel free to drop me an email. You can see my email address on the slide. It's showing at the moment, mark@digitalcompliance.co.uk, or check out the digitalcompliancehub.co.uk and let me know what you think. I'm certainly interested in even having a conversation about some of the challenges and what kind of things that you could do with help with. So thank you very much for joining. I hope you found it useful, and I'll circulate a recording and a link to the slides, so you've got that for your own references as well. Enjoy the rest of your evening and the rest of your week, and hopefully speak to some of you soon. Cheers.